administration, I was going to do a very dramatic start. Thank you for having me. It's a great delight to be here. And when I looked at the program and saw all the rich discussions you've been having, I thought I might take this discussion to the meta level and really look about the deep issues that I feel as Director of International Law of Policy, and I do feel the spirit of the forefathers in here. Look at it through some issues that are both ancient and modern, through that are both mystical and also pragmatic. And I think it makes sense as we mark this year as the 70th anniversary of the Geneva Conventions. We need to look backwards to get some gravitas, but the future just keeps coming at us. So we also need to look forward and see what is it that we need to reflect upon and adjust ourselves to be future-proof. Now, as Marco mentioned, I did spend some time, quite a lot of years, as a young delegate for the ICRC in the field. And I remember one of my first missions was in Papua New Guinea. And the great thing is, somewhere like Papua New Guinea, it was far away from the mothership of Geneva, and that gave you a lot of freedom, because not only was everyone in Geneva asleep when you were working, but no one really, at least back in early 2000, even knew where Papua New Guinea and those places were. So it gave me a lot of freedom. And now I look back and go, ooh, what was my director thinking? But that's another question. But I remember sitting opposite this very wise gentleman. He was the Minister of Health. And my job was to try and encourage Papua New Guinea to create implementing legislation to protect the Red Cross emblem. And I thought I did a really good job. We had 4 gentlemen, all with their big beards. They were high chiefs as well as members of the government. And I explained that this was a particular need to have domestic legislation, and that if you respected it, it would allow you to be able to provide humanitarian assistance. There was a number of tribal fights going on in the highlands, and we could allow that. And they stopped and they looked very wisely at me, and I thought, I think I'm getting somewhere. And they turned to me, they said, right, we understand. The Red Cross is like black magic. If you believe in it and you follow it, it will protect you. And as a lawyer, sweating in my suit, it was about 40 degrees, it was my first suit, I was about to jump in and say, no, it's a normative legal framework that allows the protective. And I stopped myself, luckily, and I thought, actually, what he's saying at the meta level is perhaps more useful as an entry point than this normative legal framework. And whilst I would say more the protection of the emblem, for example, is more like white magic, because I'm quite interested in magic, there is something there that I think we as international lawyers and practitioners sometimes forget, that there is something around, I think, at this current global environment where there is a bit of a sense that international law has lost its magic. It's not believed in, and therefore it can't actually do its job. And you hear there's a lot written about, I'm sure you would have discussed, and I think a few years ago around the World Humanitarian Summit, there was a lot of statements by the UN Secretary General of the erosion of IHL, and the great Professor Cecily and myself have been on panels sort of challenging that idea and really asking us to look a little deeper than this sense of erosion. Because I think in many ways we in this room, we practitioners, we academics, we diplomats, we students, have a little bit of blame. I think we need to carry a little bit of blame that at times our discourse can urge on despair. We heavily profile breaches of international humanitarian law. We rightly point out the unacceptability and the outrage in a world that stands by when civilians are attacked and killed, where hospitals are looted and destroyed and humanitarian access denied. The list goes on. I don't need to tell this room the list of the unacceptable breaches of IHL. And I think in my reflections, our frustrations that the great, what I would call international criminal law project of the last few decades, where we have done excellent work and necessary work in creating enforcement mechanisms at the I would say global level, the hybrid, and also at local. This idea that holding people accountable, which has really been a large percentage of the oxygen in the last few decades. I think there's many of us that feel frustrated that this hasn't revolutionised human behaviour. And I think also at the same time, the frustration we have where it's really difficult to develop new norms through consensus. A lot of people talk about the frozen multilateral landscape. In my experience in New York and covering the world globally, multilateralism appears to be alive and well. We see many, many states rocking up's a bit informal, attending the United Nations high-level week on these issues. It's just that the issues around consensus and building things based on a consensus is really, or at least in my experience, extremely difficult. So we're raising our voices on these issues, and the general public hears us, they see us, and they sometimes agree, and I've had many discussions at airports, I spend a lot of time at airports, where they basically say, oh yeah, it's not worth the paper it's written on. Why are you carrying around those heavy books? We never hear when it works. And so I think, as we know with fairies, you know, when magic isn't believed, it doesn't work. And there's something in this space I wanted to flag, this crisis of confidence that we need to be responsible and not have rose-coloured glasses. The world as we see is unacceptable. The breaches we see are unacceptable. The ICRC, more than anyone, I think, knows what happens. My heart sinks every time I walk up the hill and I see a flag lowered because there's a security incident. You know, we're not living in a la-la land, but I also think that we need to take a step back. And there's a lot of interesting writing beyond and above IHL. I don't know if any of you have read, it's a bit controversial, but Steve Pinker's book and that sort of work, where he looks at a distance and he says after World War II, out of 100,000 people, 300 died from armed conflict after World War II. It was obviously a terribly violent time of human history. And today, out of 100,000 people, 1.2 people die of armed conflict. Now that is 1.2 person too many. But we are very deeply, daily exposed to these statistics. And I think that what we've been trying to do in the ICRC in some of our work, and you may have heard about it, is really looking at IHL in action, change the narrative, trying to find positive examples where IHL not only works but has an impact, to start challenging this idea that it's not worthwhile for us to spend our time discussing, negotiating and engaging. And you know, we've got a list of database actions and collected case studies where there's examples of compliance with IHL. And in and of themselves, they seem rather small compared to a headline. But you've got in Liberia groups that have distributed medicine based on engagements with warring parties. You've got contexts such as Sudan, where we've had a lot of engagement on releasing detainees. You've got places in South Sudan where there's recruitment of children into the forces has been halted. You've got demobilisation of child soldiers in Sierra Leone, over 6,000. You've got treatment of the dead correctly in Peru. The list goes on. I don't want to go through the list. Individually, it'd be very hard to make a lot of noise about them. Although I must admit, the demobilisation of 6,000 child soldiers in Sierra Leone, I'm just surprised that doesn't have a bleep. It was a few years ago, but how can we also engage in that? So I think that we also need to come up with not just the problems, but different types of solutions or different types of ways to ensure that those who are in a position to apply IHL understand its importance. And recently the ICRC did a study, or a bit of a study that looked at the relationship between displacement and compliance with IHL. And it found that, of course, if IHL is applied even perfectly, there is still displacement of individuals, but it was able to identify specific types of violations that either directly or indirectly trigger displacement. And I think that was a very interesting way. I find when I talk to senior government officials, attorney generals, ministers of defence, ministers of foreign affairs, we've somehow got to move ourselves together with the requirement of following IHL because it's a legally binding principle, but also think about other ways to profile this importance. And I think the most interesting thing in this study, which we weren't looking for, was it showed that compliance with IHL gives people a genuine option in relation to making a return. So return after conflict. So I think there's something in this space that we need to be able to better articulate that IHL is valuable, that it's worth working for, and that in fact that the magic of IHL, which if you respect it, if you work on it, if you agree with it, will protect you, is important without a naivety. So I think there's something there about magic and international law. I think there's another big challenge today we face, and this is what I would call the dehumanization discourse. Or if any of you watch The Walking Dead, the use of zombies which is sort of infiltrating, I would say, almost contaminating some of the discussions we have, particularly when it pertains to the treatment of those who are deemed terrorists. So today you almost hear a discourse that those who commit acts of terror are subhuman. They're not worthy of legal protections found in the really well-established norms. In a way, as I said, we've taken these individuals, either individually or as collectively, and we've worked into a narrative that I just keep thinking the word zombie. You know, at the Security Council addressing them, I just think the way they're talking about them, they're human, but they're undead, and they're going to contaminate and pollute the world. And I've always been interested in zombies. I myself don't get time because I'm reading the drafts of the commentaries like Marco on the weekend, but my family have deeply followed The Walking Dead. And, you know, I so often talk about IHL with them when they're watching it, because it's really interesting. That I don't know, those of you who haven't watched it, it starts, I've only seen a little bit, but it starts with this individual who has to end up shooting a child who's turned into a zombie, and it really challenges this idea about who is the enemy. The enemy doesn't look like who we think it is, and I think the whole discourse around the way we're treating those who are the foreign fighters' families, there's something in this space about a disconnect between being human. And there's lots of great literature if you're interested on zombies, because we know it goes way back to voodoo folklore in the Caribbean. And in fact, one of the very famous and first horror stories written was just across the lake where Mary Shelley wrote Frankenstein. Mm-hmm. So it's a great place for a picnic if you're interested in that. But I think there's this idea about that we need to shake off, that IHL is for humans, and this group of humans, in fact, are coming to get us in a way that we don't quite understand and can't quite control. So as we know, the balance of security interests and humanitarian imperatives has translated into approaches we believe, bit by bit, if we're not careful and work together, will swing the cursor towards security interests at the expense of legal safeguards protecting human life and dignity. So I think that when you argue that those who are designated as terrorists are undeserving of the protection of IHL, you actually raise a theory that you can fight terrorism unrestrained. So you really challenge the almost existential, at an existential level, the nature of IHL. And what we see as examples of this is the extension of the concept of persons constituting lawful targets. We've seen overly permissive interpretations of the principle of proportionality, or selective approaches to the rules governing the detention of people designated as terrorists. And as we all know in this room, I almost don't need to say it, under IHL, the designation of a group as a terrorist organisation or its conduct of its acts has absolutely no bearing upon the applicability of international humanitarian law. So, you know, IHL is a process that is a contained framework that provides protection to those who are engaged in armed conflict. And I think one of the really serious issues we're seeing is, as I mentioned before, the first-hand issues in places like Iraq and Syria is the treatment of foreign fighters. And very interesting, really law-abiding states nearby, who really have a big political issue, which they, I feel, are translating into looking for technical answers, but in fact it's a political, palatable issue of the public, not so much a technical issue. So we've seen security measures against foreign fighters that are very diverse and include deprivation of liberty in unsatisfactory, en masse, inhumane conditions. And we've seen prosecutions of the families of foreign fighters in conditions that are really unacceptable. And I think we've got some experts in the room that know much more about it, but it's deeply concerning. We're also really concerned on this issue, this sort of flowing of this sense of humanity being taken by some and others are not human, through the increased impact that counter-terrorism measures have on neutral, impartial humanitarian action. States, and I deal with this a lot, unfortunately, states are increasingly raising the level and also the complexity of requirements on humanitarian organisations to minimise and sometimes, I would say, even eliminate risks. And I can't go into details here, but I cannot tell you how many missions I've done lately in many countries where there is a real fear that if provision is provided or we're allowed to bring those who have been deemed foreign fighters home or families of them, and there's any security risk, that will backfire very heavily on the state. And I think that this is really a heavy dialogue. We, of course, understand the legitimate concerns of the state and the need to take measures to ensure security and eliminate terrorism. And in fact, as I keep saying, IHL inherently juggles with that tension all the time. It is a very pragmatic area that finds the right balance between principles of of humanity and the legitimate right of the military to undertake action. So it's not a new paradigm that we need to be facing. But what is at stake at the moment, and I'm very clear on this, is our capacity as the ICRC from many years ago to cross front lines and deliver humanitarian assistance for communities living under the control of armed groups or those individuals designated as terrorists. I think we also see the capacity that we're being blocked to visit detainees on the other side, to recover dead bodies, to even train. And we know from our recent studies on routes of restraint that actually dissemination of IHL and pre-deployment training has an impact on reducing atrocities. We've got some evidence around that now. And that, at the moment, it's quite difficult in some situations for us under counter-terrorism legislation, particularly, I would say, clumsily implemented domestic laws that perhaps don't correlate with what the original Security Council resolutions required, limitations on what we can do. So what is ironic is, as a consequence, people suffer at the very moment IHL should protect them. Now, you might be aware, recently the Security Council put out a resolution, 2462, which we're very engaged in discussing, on combating and preventing financing of terrorism. And it's a step in the right direction. If you have a look at it, particularly some of its operative paragraphs, it urges measures, counter-terrorism measures, to be put in place in a manner consistent with IHL, and urges states, when applying such measures, to take into account the effects on exclusive humanitarian activities carried out by impartial humanitarian actors. So this is a very welcome next step. What we all need to do is make sure that states walk the talk, so to speak, and actually implement this, because it won't mean anything if it's not taken from the Security Council and implemented domestically. But I think we need to keep finding new and innovative ways to stress the point that those on the other side, whether they be the military, whether they be a non-state armed group, or even if they're designated terrorists, are not subhuman, are not zombies. They are not here to contaminate in the same way. They are indeed humans. And then my final point I wanted to flag was the issue of the need for us to reflect going forward on new technologies and weapons. And may I start by saying, I'm sure Laurent, who spoke to you during this conference, had some, as he always would do, some very erudite things to say, particularly around cyber. But what I wanted to flag to start with is, if technology is the new dragons. I don't know, for those of you who watched the Game of Thrones, I know some of you didn't. If they're the new dragons, how do we deal with it? And it was really interesting because when I was reflecting on this, and I had a bit of controversy, a few people say, you're not going to talk about Game of Thrones, it's just ridiculous, it's a TV show. I then got a report, because the New York office reports to me, my colleagues had just been in the Security Council and had been raised in the Security Council Game of Thrones. There was quite a bit of fight about it, because apparently one state, I won't name, said, this is not a game, and people didn't quite understand what was being talked about. But it was the night, it was after it was shown, after 17 million people watched it. So I think it's an interesting issue. But I think throughout history, humans have sort of progressed to try and distance themselves from killing, from looking in the whites of the eyes. And we see that from the use of arrows to catapults to aerial bombardments. And so we're always trying to reflect on that. It's always raised ethical issues. And there's some really interesting pieces written on new technologies and IHL. I'd encourage you to go to the ICRC Law and Policy blog. We've got a couple of recent articles that I've brought along here. Potential cost of human cost of cyber operations, artificial intelligence, machine learning in armed conflict, a human-centred approach. There's lots going on around there. But I also like to read beyond IHL, and I don't know if any of you have read a great book called Sapiens, A Brief History of Mankind by Yuval Noah Harari. And in that, the author traces the evolution of the way humanity has evolved, but also of science. And he moves from what he calls the cognitive revolution 70,000 years ago, to the agricultural revolution 12,000 years ago, to the scientific revolution, which he said was started 500 years ago, but really shifted when the atomic bomb was first used in July 1945 in New Mexico, when it was first let off. And the shift was this understanding by humans of the interface between knowledge and power, and the willingness to admit ignorance and to discover a world beyond our own knowledge. Because for many years it was really felt that humans understood everything. So this shift is quite an incredible shift. And he writes about the fact that there's maybe a different way we're going to pass on knowledge in the future. He claims that we currently influence, and I agree completely, through concepts and stories. I mean, humans absorb really complex concepts through stories, through narratives, through a different way. He says that he believes the future will spread knowledge through mathematics and algorithms, which is really sad for someone like myself who doesn't get maths or even exactly what an algorithm is, although I'll get Laurent to explain it to me. But I think there's something that we as international lawyers, looking into the future with the normative framework and potential use of weapons and the role that science will play in that, we really have to engage with. And we are finding in the ICRC it's an interesting times. Traditionally, when we look at weapons issues, we look at the humanitarian consequences on the ground. We are very field-based. We take those consequences, it might be surgeons that tell us too many children are dying of a particular weapon or they're indiscriminate. We run those consequences through the legal and the policy prism to check if the law is relevant. Does it need clarifying? Does it need more law? Or do we need to disseminate and explain it more? We then run through what needs to be done, traditionally engaging with states, and the aim is to bring it back to the field. And we see what I call this virtual policy and law cycle over and over again with new types of weapons that we're looking at, cyber warfare, artificial intelligence, autonomous weapons. We're having to do it differently because we can't in the same way grapple with what the humanitarian consequences are on the ground. We have to use a little bit of our imagination as well as the experts that tell us what's going on. So I think if you did watch Game of Thrones like me, and particularly the couple of ending series were fiery. For those who didn't, there's this fantastic woman who ended up being incredibly evil called Daenerys, and she was the mother of dragons. And in earlier versions, she had these dragons that were growing up, and it was great because it was going to be a great weapon against the adversary. Dragons were going to be the most powerful. And one night, I remember, I think it was... I've got it written at home. See, because I watch Game of Thrones with an IHL thing. My whole family just says stop it. One night the dragons got out of control and they flew across a whole lot of villages. This is, I think, back in season 7, and they burnt a whole lot of villages. But she was asleep at night and she was horrified, so she had to chain these dragons up in dark caves. And there was this really interesting point. I remember thinking, she's got these powerful weapons. Incendiary, they can kill many. They're seen as great things, but at what point must there be human control and human agency on the decisions of how you use these dragons? And in the final version, the last few seasons of Game of Thrones, the last few episodes, we saw a really aggressive use of one of these dragons, this time with her in control, where she burnt a whole area, King's Landing. She burnt the area and destroyed it way beyond proportionality, way beyond distinction. There was no warning in the same way that should have happened. I mean, it was a massive breach of IHL. But it also looked at this idea, and this is the thing I found most interesting, that after that incident of mass deaths of civilians, there was a real question, a deep questioning on her legitimacy to be a ruler. Whether or not someone who could unleash through a new weapon system, I would say, a weapon system that was something that others didn't have, except for we won't. For those who haven't watched, you had the dark one, but anyway, we will go back. A system that others didn't have, and the deep unease with many of the major characters, that if those of you watched it for 10 years, there'd be mass slaughter, mass torture, terrible things happening. But there was this deep unease about someone who would themselves agree to do something so disproportionate, so lacking distinction, that in the end she didn't become a ruler. And I think there's something in it that tells us the unpalatability of the basic fundamental concept that even wars have limits. There was something there that was really interesting. And if you wanted to go into more detail, I must admit, Australian Red Cross, because I was Director of Law in Australian Red Cross before I came to ICRC, have done quite an interesting analysis of each of the war crimes perpetrated during the times of Game of Thrones. I wonder where they got that idea from. It was, it's on their website. But I don't want to dismiss the very important challenges we've got, but it's fascinating when something watched by 17 million people somehow, whilst it unnerves us, sort of raises a lot of these questions. I can tell you my 18-year-old son is a little bit like, I can't talk about Game of Thrones because all my mum talks about IHL, but there's something in that space we need to look at. And so, of course, today current international levels of discussions are focusing on the limits of autonomous weapon systems, so that humans retain control and responsibility for decisions in use of force in armed conflict. And we do know that today major powers are investing heavily in artificial intelligence for military advantage, and there is actually a potential for an arms race in relation to new technologies, although I think we have to be a little careful not to put ourselves in a position of disadvantage. We also need to say that new technologies has great potential positive opportunities as well, and to make sure that we harness those. So within ICRC we see three particular areas of significant implications: artificial intelligence enabling, autonomous weapons themselves, cyber and information weapons capabilities, and decision-making systems. And so, in essence, what we're arguing at the moment for is human-centred and humanity-centred approach to artificial intelligence. And it even raises a lot of issues, I can say, at the Directorate. Not all my colleagues always agree because, today someone said to me, well, humans aren't doing a great job, so maybe autonomous weapons or artificial intelligence would do better. And the argument really is it's not that humans aren't doing a good job because they're not able to, it's the political will, and it's how you, of course, program these areas. So just in summary on autonomous weapons, we've called for internationally agreed limits to ensure human control over weapons because there's great unpredictability of some of the consequences. It is a new area, and in fact it's quite chilling when I have my colleagues introduce me to the high-level boffins that are fascinating, but after an hour I sort of get a vast majority of what they're saying, but not everything, where they show over and over again the unpredictability in this space. The second thing is this, I think, almost an ethical issue. It's not necessarily a legal one, but about humans having to apply the law. Recently, Google put out a white paper looking at what were the circumstances of which they would not, even Google, would not advocate for artificial intelligence to make decisions. And there was two they flagged. One was in complicated criminal cases and other cases before a judge. And the second was related to medical decisions to do with sort of ethical. Now, both those fit squarely, I would argue, into decisions that a military commander or someone using force has to take in weighing up considerations. So it's interesting that today, rather than starting with knowing the consequences, we have to construct the understanding of what they are using experts, and rather than just engaging with states, which, to be honest, in the ICRC world is more of a comfort zone, we have to bring in people such as, and we talked about it, we need to maybe use our convening power to find a space where we introduce the guy or the girl in the basement with the ponytail to the decision maker who influences the foreign minister. How do we make sure we bring these groups of people together that perhaps traditionally weren't always talking with each other? So as well with artificial intelligence, the ICRC is also really interested in the potential human cost of cyber operations, which I encourage you to read the report we put out recently, done by the brilliant Laurent and another colleague. And I think one of these issues is that, fortunately, to date, the use of the hostile use of cyber warfare hasn't seen large-scale humanitarian consequences to date. We know they're being used. But we see stark reminders of the specific vulnerabilities, and I think certainly from the work that my colleagues and teams have done, in the area of the health systems, there are specific vulnerabilities we need to look into about how they're advancing in the use of new technology and digital and cyber, but not perhaps having the same protections. And there's many other issues on cyber, but I think we can maybe talk about it in the break or in the questions, or I could ask Laurent to talk about it. But I think what we really need at the moment is to move the discussion to the level of focusing on how IHL applies to cyber, that even though there's existing rules apply, what is it that we need to do due to the interconnectiveness of military-civilian networks, and what are the particular pragmatic, practical and legal challenges? Now, this doesn't mean for 1 minute that in asserting we need to talk about how IHL applies to cyber that we believe or encouraging the use of cyber in warfare. They're separate issues. I think it's very important to identify and unlock these, but we've got to get our heads around this issue together. And we in the ICRC in the next year or so have got some ideas. You'll see some new things popping up. So, with harnessing the dragons of our future, we need to think really carefully and not be limited by our imagination. So in conclusion, ladies and gentlemen, as we know, this year, as I said at the start, marks the 70th anniversary of the Geneva Convention. So we know that the way conflict has changed is is being fought is changing. We know the temporal scope, it's much longer, it's protracted. We know the location, we see more conflict in urban environments. We know that the parties are much more fluid. We know that in the last 6 years, there's been more multiplication of armed groups than in the last 60. So we know these things, but we deeply believe, and I hope those in this room do as well, or at least we can discuss, that IHL is up to the contemporary challenges as long as we look at how we need to apply and whether we need to clarify and how we move forward. Because the states were not carried away by idealism when they wrote the Geneva that sat in this room. They were not requiring things that were unreasonable. They knew the realities of war. And certainly the 1949 Geneva Conventions came hot on the experience of the horrors of World War II. It does make me feel a little bit almost nostalgic that the Geneva Conventions themselves were drafted in 4 months. Having said that, when I got a little down about the 4 years we spent on a fairly soft framework, my colleagues did remind me that through the international conferences since 1867, which was the first international conference, not that long after the first Geneva Convention, at that conference was the ideas to amend the first Geneva Convention. So in a way it took 45 years, but just the 4 months of negotiation, and that would have been pretty cool. So we know we've got a body of law that balances carefully pragmatism and humanity. We know these instruments are not perfect. I think it's really important. It's powerful to show vulnerability. We know there are areas we need to work on. We believe they're fit for purpose. And in the 70 years, we're calling for 3 things. We're asking states and others to ensure there's universal ratification of all IHL-related treaties. We're asking for full implementation in domestic environments. And often that's a part that gets overlooked. As I was a consult lawyer, as I said at the start, in the field, which meant I worked with states on that, it's much more interesting for a soundbite in the media to have a new treaty created. But in fact, as much, if not more, important that these are implemented in domestic law. And we're also asking, particularly at the Security Council of the UN and other states, that they also must take into account respect for IHL when supporting partners during times of armed conflict. That's a critical one. So ladies and gentlemen, I think we need to look back to the ancient times and reflect on perhaps how we can get the magic back. We need to remind ourselves that we're fighting human beings, and we need to make sure that we have some control over the future of the dragons that might push us in new weapons. But I think my most important point is that we have to create our own tales. We have to create our own stories, our own narratives, not let others create them for us. And we cannot fail the law by having a failure of imagination. Thank you.
So, thank you, Helen. That was fantastic. I must admit that when I first saw the title of your talk, I was thinking, right, how do I respond to that? And initially I was thinking, do I use vampires, werewolves, Tolkien? I've always wanted to work on the future framework for the first intergalactic war.
Yes.
And so, you know, I had lots of ideas there, and then I decided I'll never end up being as creative as you are, and I gave up on all of that, and I'll just go with plain old, I won't say boring
never.
law. But I will pick up on some of the points that you raised. Not all of them. I don't think I could do justice to everything you've spoken about. On the question of whether IHL has lost its magic, I agree with the central premise of we should not despair. Absolutely. I suppose perhaps I'm less convinced as to the progress that we've been making as humankind. You know, there's a tendency to say that there's been progress over past decades, centuries. You referenced Steven Pinker's work, which is all very, very interesting. I find that some of these discussions do point to progress that's been made, but that progress is not necessarily distributed equally geographically. So, we can sit here and say, across Europe, going back from sort of World War I, World War II, and to today, wonderful progress and so on. But if you're living in the Eastern DRC, you might say, good years? When were the good years? And I think it's always important to remember that when we talk about the progress. And personally, I also, even looking at sort of Europe and the West, we look at the rise of populism nowadays, and from Eastern Europe through to the US, Brazil, and some Western European countries, you're seeing this. I wouldn't say I despair, but I'm less convinced that we're on a progressive path, and I think we might be in for a regressive few decades as generally across the planet, quite possibly. And so, it's not that IHL's lost its magic, but potentially rule of law and some basic values. I think we may be regressing. In the context of conflict, it's not just IHL. It's the jus ad bellum as well, and the resort to force. And again, resort to war on waves of populism is something that's coming back. Look at Ukraine as an example of some of that. Sorry for being a downer, but why do I nevertheless say don't despair? I suppose it's a matter of expectations, and this is where often when I have to sort of talk about and explain the difference between IHL and human rights law. And there's all the technicalities and there's all the debates over the interplay and so on. But one of the differences I sometimes say to my students, at least, is that, and again, this is, people can disagree, but from my perspective, human rights law is, in terms of expectations, there's a little bit of a utopian side to it. Right? So there's this hope that if we all adhere to this, we will have the perfect society. Right? It recognizes that there are balances that need to be done and so on, but ultimately it's aiming for, and most human rights advocates in many ways will be aiming for a better world. And IHL, and I speak as a dual citizen of IHL and human rights. IHL, for me, sometimes it's a more comfortable space to work in because there isn't that utopian expectation. It's an exercise in damage limitation. It's about minimizing harm. Starting point is war happens, nasty things happen. What can we do in that space to minimize the harm? And so there's no expectation of solving war as a problem. And even if you adhere to IHL, you can still have enormous suffering. But minimizing harm is nonetheless, it's a noble task. And it's one with profound consequences, and nobody knows that better than the ICRC and the work that's being done in the ICRC, because adherence to IHL during an armed conflict, it won't solve the conflict. There will be plenty of suffering, but that can still, in any given conflict, that can still be tens of thousands or hundreds of thousands of lives that are spared, and people that are less affected by the war. But I say all of this to say that at the same time, when we talk about sort of hope or not, and IHL, at the end of the day, we need to acknowledge that this is a body of law that has its limits. That in some conflicts, by the way, even if we raise awareness to IHL, even if we see militaries attempt even more and more to abide by IHL, we'll still see high civilian casualties. Some of this is due to the changing nature of war. And so many wars nowadays are fought in not on sort of 19th century battlefields, but in urban environments, in crowded areas with civilians. And as soon as fighting takes place in an area with civilians, it's inevitable that death and destruction to the civilians will follow, even if you adhere to all the rules. Right? So in a sense, in these situations, it's not really IHL that, obviously we need the IHL, but we also need more work on preventing conflicts in these zones and in these areas in the first place if we want to see any real change. On the subject of new technologies and the challenges that we're facing there, particularly with cyber and autonomous weapon systems, lots of people talk about needing new laws. Right? We've got all these new technologies. We need new legal frameworks. We need new ways to address And I think that in and of itself, not the technologies themselves, but the discussion about whether we need new laws is one of the challenges that we need to be very much aware of. It's not that I would say never to new laws. Sometimes we do need them, and the history of IHL is full of ideas for new legal frameworks, but I think we need to be very, very careful before going down this route, before ever sort of saying, yes, this new technology, new method of warfare, we need to regulate it with something new. Strategically speaking, it can be extremely dangerous to say that. There's, first of all, nothing to guarantee that any new legal framework will be better than the ones we've got. And frankly, going back to what I was saying earlier about the state of the world, I'd be concerned that any new legal framework would be worse than anything that we have. And so I would rather always try and use what we've got than develop new things. Remember, at the end of the day, who makes law? Right? It's not going to be the ICRC. It's not going to be Amnesty. It's going to be states that have the strongest say in actually creating the law. So I think we need to be very, very careful. And also, there was mention, Helen, of the speed in which the Geneva Conventions were drafted.
Way back here.
Right? If nowadays, probably, as soon as you say we need new law, you probably wait at least a decade before you have anything, if not longer. And what happens in the meantime? Because you've now admitted that you don't have the right laws to regulate this technology. So that means that those that are using it are freer to say, well, there's a gap, the law doesn't quite fit, we're doing our own thing. So again, admitting that you need new laws is awfully close to saying we don't have the correct laws right now, and there's a danger there as well. So I would always prefer trying to come up with new interpretations to existing law rather than new law. Remember, just because a law wasn't designed for a specific purpose, it doesn't mean that it can't regulate it. Right? And cyber is a very good example. So in the context of cyber operations, there are questions, for example, over whether, and we say cyber attacks, it's a word that we have to be careful with, but I always prefer to say cyber operations, right? Whether every cyber operation is an attack. So if you look at the Tallinn Manual, which attempted to sort of be the first document that tells us all about how international law and IHL in particular applies, there was a debate there as to whether cyber operations are attacks or not. And why is this important? Because, and they were saying that if you don't have damage caused by it, so that's physical damage or functionality, but functionality was in the end defined also by needing to do something physical, then it's not an attack. And if it's not an attack, they were arguing the principle of distinction doesn't apply. Right? So if something isn't an attack, it means you can conduct a cyber operation against civilian targets, civilian websites, and so on. And so understanding and interpreting this, getting it right, will have profound consequences. I'd say the Tallinn Manual got it wrong, but that is right now the document, the instrument that is most cited and quoted as being the law on cyber warfare. So we have to be careful with that. Another place where there was a problem with the Tallinn Manual is with regard to data. Is data property? Right, so again, the argument there is data isn't property. What are the implications? The implications are, if it's not property, and it links also to the question of what are attacks and distinction and so on, it means you can destroy civilian data. Right? Here, I was saying earlier, we need to be able to interpret the existing law in light of modern technologies. This is a perfect example, in my view. There's a lot to commend, by the way, about the Tallinn Manual. Lots of very good work there, very good people involved, and some excellent work there. I'm picking on the bits that I disagree with, just to be clear. But with regard to data, I would say this is an example of how to get an interpretation wrong. Okay, so what did they do there? They looked at the commentary to Additional Protocol 1, and they said, well, how do we know if something's an object or not? The commentary says that objects are visible and tangible. Data isn't visible and tangible, therefore it's not an object. It's not an object, it's not property. We don't have to classify it as such. Why would I say that interpretation is wrong? First of all, on just a pure technology basis, data doesn't exist in a cloud. Somewhere it's there as code. It has to exist as code somewhere. Somewhere you have to actually be able to look it up and see it. If you can't, it simply doesn't exist. So you could argue actually it is visible and tangible. Secondly, relying on a commentary from decades ago is, I would argue, not necessarily appropriate. It's not the law, it's the commentary. Commentaries, and as we know, there's need once in a while to update commentaries. Commentaries show that we need to change things. So, they relied on an old interpretation that was out of date. And thirdly, even if you go with that particular commentary, what does it say in AP1? Why does it say that objects need to be visible and tangible? Because it's distinguishing between objects as things and objectives as aims. Right? And data is much more of a thing than an aim. So even if you were going to use that interpretation, I think you should have reached a different result. But to me, it's a perfect example of how we could use existing law for a new technology if we get the interpretation right. If we get it wrong, we're in trouble. As for autonomous weapons systems, here, one of the challenges, of course, is understanding, it's with cyber as well, but understanding the technology and getting all of our definitions right before we even begin to talk about these. When I started working on various issues of new technologies, I decided I want to spend some time understanding it. So during some research leave about a year and a half ago, I went off to the US to the Applied Physics Laboratory of Johns Hopkins University. And so it's not particularly the normal course for an international lawyer to be a visiting scholar at the physics labs at Johns Hopkins, but the purpose was to spend time there and just be talking to the scientists and learning, about the different technologies that I wanted to work on. I still don't feel that I quite understand most of it, but at least the language is a little more comprehensible. And part of the problem with autonomous weapon systems and artificial intelligence is that we're all using different definitions. So you've got these debates, you've got these strongly held views, but even there are some states that have the exact same technologies, and one will say, we'll never use autonomous weapon systems, and the other will say, we use them right now, and they both have the same technology, they're just using different definitions. So we've got a real problem in the language, and that's one of the challenges. If we're going to deal with this, we need to understand what these are. We need to get our definitions right. In terms of how we talk about them, often we're comparing these systems to soldiers. Will they be better, as one of your colleagues said, right? Will they be better than humans or not? That's something that we often discuss. There's a question as to whether that in and of itself is problematic, because it puts us in a certain mindset where we think of them as agents. They're not agents, they're tools. One day, maybe, when we get to what some people call, the singularity moment and so on, maybe we'll have artificial intelligence and that are legal and moral agents, and then it'll go to all sorts of interesting places in society, and your best friend will be a robot, and maybe more than your best friend. But one day, maybe we'll be there. Right now, these things are tools. And if they're tools, then when we talk about them legally, we need to be thinking about them the same way we would think about any weapon system. So we shouldn't be comparing them to soldiers, we should be comparing them to other weapons systems, and what are the laws that apply with regard to weapon systems. So if I use this weapon, can I abide by the principle of distinction? And with relation to some of these systems, if I can abide by the principle of distinction, then it would be lawful with respect to that principle, right? If, and right now, most of these systems cannot, right, then you can't use it. But that's a technological problem. It's not in a sense a legal problem. It's not an ethical problem. It's a problem of the technology. Right? If you can't use it in a way that distinguishes, then that's it, illegal. If you can, from that perspective, why wouldn't it be legal? So that's the same with most of the IHL rules. I think there are technological questions of, is this a weapon system that can be used in compliance with IHL or not. There are other questions that I would argue are not questions of IHL. They're bigger. They're not necessarily even legal questions, never mind sort of outside the IHL framework. So the fear that if we have autonomous systems that are AI-driven, that this AI will be able to reprogram itself and go on and decide to do all sorts of things that it wasn't meant to do, and decide that it doesn't need to abide by IHL because it's more efficient not to, and so on, and the big risks of that. Absolutely, that's a scary thought. But why is that limited to IHL? Why is that limited to the battlefield? Right? If you have an AI system running the sanitation in your municipality and it decides that it's just a lot more efficient to poison the water of half of Geneva because it'll be much cheaper in the long run, it might do that. It's scary, but if we're scared of AI, it's got nothing to do. AI doesn't need to hold a gun. Right? If you're worried about this AI that does ridiculous, crazy things, it can happen anywhere. So I don't know why we're discussing that in the context of battlefield. That's a general big discussion that needs to be happening, and is happening around AI. Right? And I sometimes worry that the discussions that are happening in the IHL field with regard to AI are taking our focus away from the bigger questions we need to be asking. And it's making us sort of think that if we solve it here, we're okay. No, we're not. The problem can just come from somewhere else. So it's actually a discussion that I think needs to be taking place in a different forum. Discussions over whether machines should be involved in the taking of life or not. A really interesting ethical question. And again, not one that is limited to the battlefield. So medical care was mentioned. Should you have systems that determine when to turn off a life support system based on an algorithm or not? But even the autonomous cars, this is something that people have discussed and raised often. It's almost a cliche now to mention what we call the trolley problem, right? But with an autonomous vehicle, and it's got to decide, right? Basically, there's only two options for the vehicle at some point. You stay on course, and the people sitting on the back seat are going to die, or you go up on the pavement, and the people walking on the pavement are going to die. Who gets killed? Right now, what the cars do is they quickly hand it back to the driver, right? Because it's you decide, right? But that's not going to be realistic in the future if these things ever sort of do get used in an autonomous method. So these are questions again that go far beyond the battlefield, and I think we need a lot more thinking. Some of these challenges. We need a lot more thinking outside of the field of IHL if we really want to deal with. So that brings me back to my starting point, I suppose, and to close with. The challenges, and a lot of the challenges that we're seeing and that were mentioned in relation to IHL are part of a bigger picture. They're part of a bigger picture of challenges that we have across society, and not just in relation to how war is fought and against whom and with what. But there are bigger questions over fundamental notions of rule of law, of the values in human society, principles of humanity, our relationship in the future with technology, and particularly with AI. And most of these can't actually be fixed by us in the IHL field. We need to be more immersed in the bigger picture, in the wider debates. We need to understand all of that, and we need to draw from that in terms of the work that we do in the field of IHL. Once we do that, we can use humanitarian law as what it's meant to be, a crucial tool for alleviating some of the worst manifestations of harm that humans can do to each other, and play an important role in marching society forward. But I think the point is that this is all part of a bigger picture, and I think we sometimes need to remember to step outside of our zone and work within all of that. I only touched upon a few of the things, Helen, that you mentioned, but I'd like to say thank you once again for such a fantastic presentation, providing us with an eloquent, entertaining, creative, and most importantly, forward-thinking approach to the role of IHL in modern times. Thank you.
We could debate some of these things, because I actually absolutely agree with you about the fact that we are in a time where the rule-based order is under stress and pressure, and so there is no naivety in that. I just think we can control a bit more of the narrative than we sometimes let happen. Kinetic attacks, data protection, all these issues are critical. So there's depths of stuff we could have a fun engagement together, but perhaps I'm sure you want to throw it to the audience.
Yes, so first to thank both of you, and to consider that there was really a very perfect complementarity, because Noam did not simply say, I agree with everything, but he did not either say that he disagreed. There was really a complementarity of two different approaches towards the same aim. But now we open up to the discussion. to remarks, questions, please. Paula.
I take the floor, and thank you for your presentation and your response, Nolan. I have two sort of questions coming very quickly. You mentioned, Nolan, about the fact that the human rights law is more utopian-driven, while IHL is more pragmatic. But my understanding when I was a student that also IHL lawyers, such as Harry Dunant, were aiming at an IHL utopian component, namely that by putting a lot of rules on fighting wars, it would be impossible to fight a war without violating the law. So their aim was a pacifistic aim. So to what extent do we have lost this pacifistic aim by dealing with IHL? And secondly, when it comes to the artificial intelligence scenario, I totally agree with you, it's not specifically an issue for IHL, but I think that perhaps something that we have not taken from the general discussion is that, for instance, in the field of autonomous cars, discussions are taking place about changing the law to make criminal law adapt to these new technologies, which is something that I don't see very much occurring in the field of the debate on lethal autonomous weapons, namely who takes responsibility if the wrong decision is taken by the machine or by the human behind the machine. So these are my questions to you. Thank you.
Thank you so much. Only Gino was a pacifist, but is IHL pacifist? Is it the aim of IHL to make wars impossible? Is that realistic, or the end of IHL? No, not because IHL should end, obviously, but when wars end. But isn't it the end of IHL to say we try to avoid war through IHL? Helen?
Well, I at least think it would be the end of ICRC, whether it's the end of IHL as our job in Guardian. I think there's constant balance, and I feel it all the time engaging with my colleagues, say the Director of Operations, where our job is not to go in and point our finger and say you cannot do that war engagement. Our job is to go in and say these are the limitations. So I do think, though, there is a much deeper and more complex relationship between IHL and peace than sometimes, I must admit, we in the ICRC want to unpack. But I think if I, as Director of Law, next time I went on mission, sat down with the Minister of Defence and said, I'm going to make it so difficult for you to fight that you're not going to bother go to war, I'm not sure I'd be invited back, and I'm not sure our influencing strategies. So I think it's fascinating as you articulate, when you look back in the history books, you go back to the early editions of the International Review and others, to see, I would say, a lot stronger ease, and all I can talk about is the ICRC, with this interface between war and peace. But I think today, in complements, as you mentioned, with human rights, with environmental law, with refugee, in the complementary nature, I think IHL is going to be more effective and more efficient in reducing suffering if it does take as a starting point, not agreement with war at all, but that this is the situation, this is how we limit it. But I do think, once again, we need to challenge ourselves on these issues. And I do know there's a lot of discussion in my own department, and I think we raise it a bit publicly, the issue of attribution and new technologies. It's not the essence of where we're coming from, but whether it be artificial intelligence, cyber, or others, the attribution issue is critical. And perhaps, if I may just flag on cyber, one of the issues is incorrect or overestimation of attribution, and therefore what might be a small use of a cyber attack could then potentially result in a counter-attack that is much bigger and moves us more into a war environment. So there's something we need to explore there. But I love the idea that in this room they thought they'll make war so difficult it won't happen. But I think, sadly, I feel sad as Director of Law in 2019, we have to have a fairly tight parameter to move in.
And again, I'm separating the history from the developments since, and I think nowadays, generally speaking, if you're asked to explain what IHL is in one sentence, you usually go back to the balance between military necessity and humanity, right? And if that's your starting point, then your starting point is not a pacifist one, right? I actually recently was at a different conference, and it was something that Bill Shabus was saying at a conference. I was with him, and he turned around and he said that he remembered 10 years ago at another conference that he and I were at together that he had said something to do with right to peace and so on, and I'd said something about IHL. If you're treating IHL as a pacifist, it's like a vegetarian trying to run an abattoir, it won't work. And we had a little debate around that. So there are different views, and I think there are people that do take that view that there's a pacifist aim to it, and that we shouldn't shy away from that, and it should happen. And I understand, and I respect that's a legitimate position. I don't see personally. I don't see that. For me, it's a pragmatic body of law that allows to engage with diverse audiences. In particular, working with military and humanitarians. It's interesting, by the way, and again, when I'm talking to my students, I often say to them, when you finish your studies and you go and work, if you're working in the human rights field or IHL field, you might find very different experiences in the human rights field. And again, I say this as someone who is also in the human rights world, but it tends to be much more a sort of you're with us or against us. Right? I mean, when you're engaging with there's if you don't have the same view, then no, that's. You're part of the evil crowd in a sense, and vice versa on both sides. The antagonism is much field. You can go and sit there with a bunch of people from the ICRC and the military and people from different organizations who have very, very strong different views, and at the end of the day, they'll all go out for a drink. Because that starting point is one where everyone recognizes there's a balance, that there's a bit of give and take on all sides, and that and that it's not either or, a total either or. So I think that's built into it. It's manifest even in how we engage as different communities with this subject. On the question of responsibility and autonomous systems and artificial intelligence. So again, some of that comes back to is this a weapon or an agent? Right, so one of my PhD students who completed his PhD just recently, that was a major part of his thesis, was looking precisely at sort of accountability, but looking at the difference between treating these systems as weapons or agents. And I think so long as we're talking about them as weapons, we don't need to be overly afraid of the accountability question, in that if it's a weapon system, then like all other weapon systems, there's the commander that deploys the system. Whoever makes the decision to use a weapon system will have some form of accountability. It requires work from the technology aspect of the issues of explainability of algorithms and so on. And there's lots of debates around that. But ultimately, if it's a weapon system, then accountability will be the same as for weapon system. And I think also we need to remember that it's not always just about individual accountability. So obviously from an ICL perspective that's key, but IHL is state responsibility. There's not as much of a problem there with state responsibility. So that's always going to be there.
François.
An issue that I think is not looked at enough is the issue of inverted commas implementation. There are very many people who think it just means passing domestic legislation. That's rubbish. I think there are very many players out there who violate the law of armed conflict, not because they're indifferent to violating it. It's not a top priority, but they're not trying to violate it. It's not that group. But they actually, and it happens in human rights law as well, they don't know how to convert a legal requirement into what is the national policy you need. For example, you need a system for gathering information in order to enable you to determine what is a military objective. You need to take into account things like the risk that with human intelligence someone may be settling scores. Is there any chance that much more could be done on basically coming up with almost lists? Here are lists of things you need to put in place without which you cannot give effect to law of armed conflict. And can we stop calling it implementation, calling it giving effect? Because it's giving a misleading impression that you mean national legislation. And the other comment, which goes, I think, to what both of you were saying about the rule of law, the one context in which I have a certain sympathy with members of armed forces is when they know that in their home country the police get away with brutal murder and are never called to account, and yet suddenly, all of a sudden, armed forces are suddenly supposed to behave in a miraculous way. You can't begin to engage in improving, getting armed forces to agree to accountability unless you address corruption and accountability for all state personnel. It all goes together.
Any comments to that, or perhaps we take
a couple or more and we'll come back.
We take two more questions, please. Don't say you are.
They're tired. They're waiting for their drink.
No one wants to ask a question about enforcement.
Just point a finger at someone. Just say Laurent. Ask a question.
This is what I do.
Come on.
My classes, but this isn't even English.
Well, perhaps to give them thinking time, we can quickly respond. We can give them thinking time by quickly responding.
So,
not with music, but with some engagement. Thank you. And you're right. I mean, we in the ICRC talk about the implementation, but of course, implementation, I'm looking at my colleague Anne here, who's in charge of that area, is much deeper, and it goes down to doctrine, it goes down to basic things. If you're looking at cultural property, you've got to identify what the cultural property is first. So often, I mean, certainly my experience, you have to bring way beyond the implementation. You have to bring in the ministries in charge of the environment and all sorts of things. And I think, I mean, I hoped I flagged that in my speech. I think it is a time now, and you'll see at the upcoming international conference of the Red Cross and Red Crescent, our resolution on IHL is not the proposal to create a brand new infrastructure, or that we, you know, someday that will happen. Someone sitting in this room in 50 years will be able to talk about it. But to actually say, you know, bringing it home. Everyone has an obligation. Everyone should be able to, say, from a state point of view, set up an IHL committee, which is a starting place for these discussions. So I do think we need to sometimes shift the spotlight of the creation. I mean, you're probably a bit younger than me, but I grew up as an international lawyer in the 90s.
I think we discussed this once, actually.
Oh, okay.
Yeah.
Anyway, we'll just have a drink. In the 90s, and there was a vast development of international laws. I mean, we saw weapons laws related, like the Landmine Convention. You saw the ICC, the ad hoc tribunals created, and it's a bit like, I look at my wonderful young lawyers today. It's like, oh, it's a little bit. There's not a lot happening. We had a few, but it's not a time to therefore to sort of put energies into areas that we're not going to through consensus or through creating. It's time then to say, what have we got, exactly as you articulated? I mean, one of the things we did in ICRC is take a big step back and scan all the types of new technologies, from nanotechnology that really is Harry Potter science, where they move the atoms so fast you can have a cloak of invisibility. That is interesting. Environmental modification, human enhancement, and we've got a big list of all those and the groups globally working on them. And there's a lot of things. There's an environmental modification treaty that was created many years ago that is completely lost. So I too, and it comes back to you, I think we have to be very careful of the seduction that we have a problem, we must create something new. I think we need to look at not only how we bring IHL home and bring it back, from teaching it at schools to ensuring that it's more deeply. I quite like the word implementation, but maybe we say respect for or application of or something more wider. But we also need to be humble as how far we can advance at certain times in current environments. So thank you for your reflections, and the interface between the law enforcement paradigm and quality of the law enforcement officers and the IHL paradigm is critical. And in the Law and Policy Department, we have military officers as well as police officers, and it's fascinating to see the need that we have to interlink these two. I use the opposite. People often say, oh, you know, the military is facing off against bad guys. They need to be able to do what they can. And I say, any government, any state realises the difficulty that they're in if their law enforcement starts acting like those they're fighting. So I think there's a rich discussion to have in both of those areas.
Mm-hmm. You mentioned the 90s, and it reminded me, and this is in relation to an earlier comment from Paula's questions and pacifism, and then you were talking about the end of IHL or not. So, you know, will we need it? I remember working with a particular human rights NGO in the 90s, and there was some hope at some point in terms of the Israeli-Palestinian conflict that it was coming to an end. And we had a staff meeting, you know, what do we do when the occupation ends? And, you know, do we shut down the organization and you know, move on? Do we do something else? And so this idea that, well, yes, again, talk about being naive. Yes. But this idea of working towards, you know, your own redundancy and making yourself irrelevant is a wonderful one, but I say, don't have that expectation.
I think we'll all have jobs like this.
Yes. Well, Françoise, in terms of giving effects, I'll just use that comment you made just to plug the joint Geneva Academy ICRC project on guidelines of investigations.
Indeed.
because that is, I think, a perfect example, and there are people here who have been involved, and Claire, our researchers there at the back, and Françoise, you've been part of it, Marco and others. You know, there's something where we're putting together a tool that hopefully the ICRC will be able to use on a regular basis with essentially all states involved in conflicts, and saying, here's some advice on things you need to do practically if you want to give effect to some of your obligations. So you know, there are things that can be done, and there are some projects out there that I think are working towards that.
Please.
Well, just to jump on the issue of implementation, we are just finishing a 3-year research project funded by the ICRC in the United Kingdom on human rights law implementation, and one of the findings is that although everyone talks about an implementation crisis, what we found through all the countries and treaty monitoring bodies and regional bodies that we looked at is that there is actually more implementation that we actually acknowledge. And that is partial implementation, and one needs to unpack that partial implementation, but that actually needs to call for a reflection. Why are we failing to note the steps that states are giving forward in the right direction? This is a process. Implementation is a process, it's not a result. So what can we do as people who are really interested in this area to actually showcase the good examples? What can we learn from that practice? We need to distill that practice, and I think personally that we need self-reflection on that. What can we do that we are not actually doing? How can we engage more with media so that media actually learns how to talk about IHL, but how to also show the good cases? And I think we need to think very carefully about our methods of work, both in IHL as well as in human rights. But I'm happy to report that yes, there is. I want to be hopeful, and I think that our project will show in our publications that are coming up now that that's the case.
And you used the word hopeful, and I think there's a distinction. I can't remember where I was reading some philosopher that was writing about this between being hopeful and being optimistic.
Yes.
Right?
There's
So
hours of debate on that.
an optimist will assume that things will be okay. No. Hopeful, you know, and so I'm not an optimist, but hopeful means that you know there's still a point in trying. You know, it might not necessarily work out, but there's still a reason to try.
Yeah, there's a big debate on that, and I think that I can't imagine on a beautiful sunny Geneva afternoon when we could all be frolicking in the water and drinking wine. There has to be a degree of hope of people to come along and actually listen to this. So I think it's moving beyond this naivety that actually what we're dealing with, it is unacceptable, but there's things we can do, and to have that energy. And now we can have a drink.
Thank you, though. Well, we will not do it like in China. I was once invited in China, and there was a question and answer session, and I found the questions by the students were so incredibly interesting, and I congratulated Professor Bin Jia.
Oh, yes.
He then told me, well, and we exercised that for 1 week. We didn't make it, but please.
I think you're right.
Otherwise, I make a remark she cannot make to what you say, which is absolutely right. But it's incredibly difficult in IHL, more than for human rights in my view, because IHL is always about parties. And if you report a state which commits, and all states involved in armed conflicts commit violations, but that this state has also fully complied in one instance, for the ICRC it's very delicate to make that public, because that state has an enemy, and the enemy doesn't like that, because precisely what she explained, they want to dehumanize the enemy, and this is part of the warfare, of the lawfare, to say the enemy does not state X, and I could give a wonderful example, never respects IHL, and if they say here's an example where they respected, or armed group B, I'm sure I could find also instances of respect of IHL by the Islamic State. But to make that public, I understand that the ICRC wouldn't like to put it in the database IHL in action.
Well, there's this deep philosophical thing we're struggling with, which is, I would frame that as inverse denunciation. So we don't denounce when but I think within that too, and the way we've done it, as you will be aware, because Marco has been involved and helped us launch it, is to find public sources, to really try and find different ways. But I think this idea about the sensitivity of what states are trying to do to each other and particularly to non-state armed groups. And yes, we have many examples, and they're fascinating examples where non-state armed groups themselves are following IHL, put out declarations through either religious articulations or others. And I suppose the frustration sometimes comes as when I had it recently. I was going to Wales to give a big talk on IHL. I got to the border, had a customs gentleman who said, "Where are you going? Why are you going there?" Looks at my passport. It has Iraq and all these wonderful countries. So they always take a long time asking me who I am, what am I doing. And he said, "What are you going to do?" I said, "Give a lecture." He said, "What on?" I said, "The laws of war." He said, "Waste of time." And I was like, you've spoken to the wrong lady. But I looked behind me. There was a long queue behind me. I thought, well, I'll let him get by this time. But it really hit me that was his gut reaction. And I will go and try and find him again next time when there's a shorter line and have a bit of a chat about IHL in action, give him the website. But there's something in that space.
Please.
I think we're in time.
I have a question for Mark,
Please.
because you wanted me to ask a question.
Thank you.
It took you 10, 15 minutes.
He's a shy one. He's smart, but he's very shy.
We discussed before the development of the law versus clarification.
Mm-hmm.
And you highlighted the challenge with regards to development of the law, which I agree and
we do,
the risk that new law would not necessarily be better. But two questions. One with the relationship between two. Why would clarification be better than development? Because you can also have clarification which are actually very permissive interpretation of the law, with the additional problem that you have different interpretation by different states, which leads to something unclear with regards to where does the law stand. And the second thing is, with regard to development, there are regular development with regard to IHL, but only weapons.
Yeah.
Do you have any thoughts on why only weapons and not on the rest, and why you have this double track of having AP which are stocked in 77, and everybody agree that maybe we don't want to touch it because if we open it we have nothing better today, or even worse. And on that other track, kind of not so far away, we continue to advance.
Mm-hmm.
The world of the states continue to advance.
Yeah, I know, it's a very interesting point that you make, and I think part of it is structural or procedural. So for weapons, there is a particular forum and the basis of one particular treaty through which states meet and discuss this, and it's almost sort of there's a dynamic of a history of doing that, right? And almost an expectation that once in a while, what will be the next big thing. I think to a certain extent makes it more likely to happen in the field of weapons, but I think also there's an assumption with weapons that this is something new because they are often related to new technology, which again I think gives this impetus to come up with. But I think more importantly, this question of development over clarification. The reason I fear development more than clarification is that with clarification we're still within the same box. Within that box, I might be here, you might be there, but we're in a box, right? We've got the current law. And when you start saying we need new laws, there's I think a concern that some would say, well, actually we're not in the box, right? The current law simply doesn't apply, it doesn't work. We've admitted that the current law doesn't apply. Yeah, you might not think that, but that's what some will, say and do say. So that we've got these gaps, and when you start talking about gaps, the fear of what might happen in the meantime, while we're developing the new law, for me is the reason that I would prefer to use existing law and new interpretations, just so that we stay on the playing field rather than move somewhere completely different. You want to come back on that, I can see.
Last chance. You can give him a reply over the cocktail. Last chance. then I would like to thank very warmly Helen Durham and Noam to have had this very interesting and again complementary discussion, which indeed crowns from somehow on another level the discussions we had during the whole day and the discussions we at the Geneva Academy on technical issues, but also on more policy-related issues will continue to have. Thank you so much, and thank you.